Good afternoon, everybody. My name is Nate Riley. I am the Chief of Transportation for the Colorado Public Utilities Commission. Thanks, everybody, for coming. Really appreciate you being here. Just so everybody understands, this is part of a three-part training series that we're doing here at the Commission for the towing industry. So we're going to talk about some topics today, but we've also scheduled some additional training seminars that are going to be coming up over the course of the next couple months. So today we're going to be addressing legislation and rules, those being commission rules, and extending out to next month on November 17th, same time, 1 p.m. Start time. We're going to be handling administrative overview, which is things that are more on the administrative side of things, regulation-wise, kind of what the permitting process looks like, the basic regulatory framework, federal, state, local, the number of active towing carriers, things of that nature. And then moving out to December, we're going to hold the next training seminar after that on December 8th. Again, same time, 1 p.m. start time. And we'll be covering things such as complaints, investigations, enforcement. So things like what the PUC's enforcement responsibilities are, best practices for towing carriers, the do's and don'ts. How the complaint process works, what the expectations are of you when you are subject to that process, things of that nature. So definitely appreciate you all being here to kind of kick off this training series. Again, today is going to be more about legislation and rules. But before we even get into that, I wanted to go over a couple of kind of housekeeping items before we get started. So first off, just wanted to let everybody know we do have a presentation for this. So our primary concern is to get through that presentation that we put together for this. Just to eliminate things like background noise and other distractions would be helpful for everybody if you could keep your cameras and your microphones off for the most part. You can control this through the buttons at the bottom of the application to mute yourself and turn your camera off. For people attending by telephone, you can mute and unmute yourself using *6. Just in case anybody's participating here using their phone. If you have any questions at any point during the presentation, do feel free to use the raise hand feature in the Zoom platform. Again, you can do that through the buttons on the bottom of the application. If you're attending by phone, you can use *9 to raise or lower your hand. Once you've raised your hand to indicate you'd like to ask a question, we'll try to call upon you as soon as possible. If you have any more specific questions, you may want to wait until after the presentation to address them. We don't want to get too sidetracked as we're going through everything. We should have plenty of time for more specific questions at the end of the presentation. So if you do have any more specific questions, feel free to wait on those. Likewise, if you've been cited for violations in the past for whatever reason, some of you may have, this isn't the time or place to discuss that. Yeah, you can always reach out to our investigations team if you have any questions about that, but we don't want to get too sidetracked again. More specific topics that we're going to be covering in this training. Also, just as a general point, please understand that the towing industry is subject to statutes and regulations from both the PUC and the Department of Revenue. We will probably get into that a little bit later, but it's beneficial to at least understand that both agencies do play a role from an oversight standpoint based on what type of tow you're performing. So just understand that there is a difference between the state agencies and kind of what we regulate as it pertains to regulation standards, all that. Also, just kind of a general statement here. There are three kind of primary tow categories for the state of Colorado, which actually is the same way kind of across the state, multiple states, which is the consensual towing category, which is your basic, broke down on the side of the road and need a tow to your home or a mechanic shop. Non-consensual tows, also referred to as private property impounds or PPIs. Those are somebody's parked where they're not supposed to on private property, and the property owners or managers want the vehicle removed for whatever reason. And then finally, the third primary category is law enforcement order tows. Those are typically all public property tows are going to fall into that category, since law enforcement officers are really the only ones who can authorize tows from public property. Or maybe it's something else, post-crash, post-arrest, those types of situations as well. Further, which we're going to be getting into a little bit later, one of the key differences based on recent legislation is that non-consensual tow private property impound PPI category has been or we're attempting to further split that into two essentially subcategories of tows, which is residential PPIs. So those are non-consensual tows originating from more residential style private properties, and commercial PPIs, which is again the opposite of that, which is private property impounds that are originating from more commercial style private properties. So those are all some of the things we're going to get into today, but just wanted to kind of start by covering some of those bases. Let me go ahead and get the slideshow started here, and we'll go ahead and jump right in. One moment, please. Okay, so hopefully everybody can see that. So we're just going to go ahead and go through this. Again, today we're going to be covering legislation and rules. So we'll be just kind of going through that. But I wanted to start with a couple other things first before we get into kind of the meat of those. And these first couple parts here, I'll probably be covering in all the different trainings, so that everybody can kind of get a feel for some of the things that are just kind of general things that the commission wants everybody in the towing industry to be aware of. So we're going to start with the website. There's a lot of good resources you can get from the PUC's website. We've taken a lot of steps over the years to kind of refine exactly what is on this website and different resources and tools that can be used through the website. A lot of good stuff on there. So if you essentially type Dora PUC into any basic web browser, we're the first thing to come up. And so you can go to the main commission website, which is what's being shown right now. And you can see there's different things just on this main page that can be helpful. Things like the calendar. So if you scroll a little bit further down from what I'm showing right now, you can see the commission calendar, different hearings and other events that are coming up. You can also just see various forms and other available resources that are there that I think personally are pretty good. On this first page, you can also see the different industry, and we went ahead and highlighted the transportation one there. So if you're on the main web page, that's how you get to all the transportation related websites. We kind of split it up into different websites based on the different industries that we regulate in transportation. So, but that's where you start, is just by getting to the main transportation page. One other thing that's good on this main PUC page is the e-filing system. If you're ever in a situation where you need to participate in the e-filing system in any way based on, if you're involved in a particular proceeding or something like that, you can see right here in the blue banner on the top of this main page, it says the e-filing system. It's the second one from the left. So you can get there from there. So moving on to the transportation page. So on the main transportation page, you can see, again, all the different industries. You can link to them from right here, where it actually identifies all the industries that we regulate. So if you needed to get to household goods, for example, you just click right there and that'll take you to the household goods page. Same thing for towing carriers. So you just click on that little towing carriers link right there and it'll take you right to that page. Another thing that's helpful here on this main transportation page is if you scroll a little bit down from what I'm showing right here, you see it's like a blue box that is headed by rules, laws, and decisions. From there, the very first link within that box is rules for transportation. So if you ever need in a situation where you need to get your hands on the rules or take a look at certain rules, you can click on that link and that'll take you to a kind of one particular PDF document that you can download. It's I think 100 plus pages. So it's all the different industries that we regulate and all the rules that apply to those different industries, but it's all contained in a singular PDF document that you can download. I recommend everybody just download it and keep it on your desktop. That way you can easily refer to it later if necessary. And just reading through the rules in general is usually a good idea. You can always call us afterwards to ask questions if you have questions about anything or you're curious about something. Feel free to reach out at any time. So selecting the towing carrier option here on this main transportation page will take you to the towing specific page, which is this one here. So We've kind of redesigned this website a little bit over the past year plus or so. And we're still always looking for ways we can improve it and all that. So if you ever have any feedback for us, please let us know. But anyway, there's things like consumer advisements on here, some notices for things that may be going on. So again, we're kind of in a constant stage of redesigning this website. So again, always let us know if you have any suggestions on how we could make it a little better from the industry standpoint. But you can do a lot of things here. You can reapply for your permit, renew your permit, purchase stamps. The tow rates is a big thing here as well. We do post all the current tow rates through the button that's available here. So if you just click on that, it'll take you to a drive where you can download. We simplified it into simple one-pagers. So you can print off all the current rates to know what the maximum rates are for non-consensual tows, PPIs, and law enforcement order tows. All of those rates are available there on the website. We also have in that same area basically a bunch of PDF documents, also one-pagers from previous rates, because due to the new annual inflation adjustment, these are now changing on an annual basis. So we have the ones that are current, but then also previous versions, just in case people want to see those. Also, I'm sure all of you are aware this is where you get your monthly fuel surcharge. So if you're not sure what you can charge for mileage, if that's something you can charge for the types of tows you're doing, you can click on it there. We tend to update it pretty quick at the beginning of the month. So definitely appreciate you going there and looking what that is when you're kind of setting yourself up for what you can charge for mileage in the upcoming month. There's also a link here to the Towing Task Force. It's basically a specific web page we have for that body that most of those members are appointed by the governor, and they make recommendations to the commission on tow rates, specifically non-consensual tow rates. So, but a lot of other good things here, common forms, business forms. If you need to update your company name or your contact information, that's all available here as well. So a lot of good things here. Encourage you all to be there, go in there and take a look if you haven't already. And yeah, there are a lot of good things there that you can use. Moving on to rules. So again, when you go to that main transportation page and click on that link for rules, again, you'll download this overall set of rules, and this is what it looks like. Just so when you click on that document, you'll kind of understand what you're going to be seeing. You have the 6000 series, which is our scope, our general provision rules. So that applies pretty much to all of the carriers that we regulate. So you always want to be aware of what's in that general provision section. It includes things such as insurance requirements under Rule 6008, for example, or how you file your application, what kind of information you need to keep on file with us in regards to names, addresses, phone numbers, email addresses, things of that nature, external marking requirements, things that kind of are pretty unilaterally applied across the board to all the different types of carriers that we regulate. So definitely make sure that you've read through those. I think it's 20 or so rules. So make sure you read through those and understand what the expectations are based on those rules. And again, if you have any follow-up questions, you can always reach out to us. Moving on to the safety rules. So this is our 6100 series. For a lot of towing carriers, there's a lot of deference to 49 CFR. I'm sure you all know that you're, in the most cases, operating commercial motor vehicles, or at least what are defined as commercial motor vehicles by the federal regs, 49 CFR. So if those apply, again, a lot of those expectations in regards to safety rules are kind of expected to be upheld. So again, just be aware of that. And if you have any questions about that, you can always let us know. And then finally, the towing specific rules. So these are the rules under the 6500 series that apply just to towing carriers. So you're going to find a lot of things specific here, such as your application process, disqualifications based on like criminal history and other things, equipment and safety standards in that area, authorization standards, fees and charges, fees disclosure, rates, release procedures, notice, a lot of different things outlined in a lot of those rules. Also some definitions that are more specific to the towing industry under Rule 6501, for example. So a lot of good things in there. It's 20 or so pages, give or take, last time I checked. So definitely want to read through those and understand what your obligations are. Again, some of the rules are set up in a way where they apply to certain types of operators that are performing certain types of tows. So again, going back to that 3 category of consensual, non-consensual, and law enforcement ordered. Some of these standards are only going to apply to one or maybe two of those categories. But consensual tows in general is not as regulated as the other two categories. So just be aware of that. We tend to point that out within the rules when that is the case. So keep an eye out for that in some of the first parts, beginning parts of some of these rules. Usually it'll indicate for non-consensual or non-consensual and law enforcement or something along those lines. So keep an eye out for that. Moving on to some other requirements that you're expected to adhere to. Just make sure you understand the PUC's general statutes, which is our title is Title 40. So 40-10.1 is where most of the transportation statutes are housed within the statutes. So 101 to 118 under 40-10.1 are our general statutes. It's what gives the commission its authority to regulate the various forms of transportation. It also allows us to engage in things like rulemaking. It's where the standard is to make sure that basically regulated carriers have the requisite amount of insurance and financial responsibility. That's under 40-10.117. So yeah, just understanding those general PUC statutes and when they apply to you is definitely important. More specifically to the towing industry is the 400 statutes. So that particular article. 40-10.1, 401 through 410. It used to be, I think, only like 3 or 4 statutes. Now it's up to 10 statutes based on the legislation from last year. And we'll get into that a little bit later. But yeah, that's where the towing statutes are. So the requirement to be permitted through the commission, for example, is in that range of statutes. And then a lot of the new statutes that were incorporated through the House bill from last year, that's in that area as well. Also be aware of the Title 42 statutory obligations. Title 42 is mostly attributable to Department of Revenue. So DOR has a lot of a hand in that. Things like statutory notification, for example, when you tow a vehicle from private or public property, there are statutory notification provisions that need to be adhered to, which are under Title 42. For public property, it's 42-4-1804, and for private property, it's 42-4-2103. So those are the two statutes you'll probably deal with the most. But then there are adjacent statutes in those same areas which explain exactly how it works when you want to subsequently apply for title and sell the vehicle to recoup some fees and all that. That's all in Title 42. So just make sure you understand the provisions there and what your expectations are. Furthermore, I know we talked about this a moment ago, but 49 CFR, which is the federal regulations, so that's US DOT and FMCSA. So be aware of what the standards are there as well as it applies to your operation based on the size and weight in the vehicles that you're using. And then there's also local requirements. So always be aware of whatever jurisdictions you're operating in, whether it's the county level, municipal, all of that. Just be aware that there may be some additional requirements on top of what the state at the PUC already requires of your towing carrier. So for example, the biggest example I can think of is in Denver County, where they have a lesser drop fee than the commission has typically allowed over the years. I think last I checked, it was $15. So just be aware of that. It could be other similar things in other counties. So always check in with your local jurisdictions to make sure there's nothing on top of what the state already requires is a good idea, just so you don't, even accidentally breach any of those standards. So moving into the rulemaking process, just wanted to make sure everybody just had kind of at least a basic understanding on how the rulemaking process here at the commission works. I'm sure some of you probably already have some basic understanding on how it works, but I wanted to kind of go through it a little more and make sure you all understand exactly kind of how it all works, at least in the background, as the commission is going through its various rulemaking processes, which it's done over the years and continues to do. So first off, starting on how a rulemaking is initiated. So typically it's one of two methods, which is a petition to the commission, which anybody can do. So anybody can file a petition to the commission saying, hey, we think you should change such and such rules because of such and such reasons. And they file it, the commission addresses it, and they can accept it and get something moving, or they can reject it if they don't think it's necessary. Another way that it can go about is the commission recognizes, of its own accord that some type of rule change is necessary. Maybe it's a policy change or something like that. or if statutes change, sometimes they will proactively initiate a rulemaking to accommodate for that, things of that nature. So they do that upon their own motion, and that's another way that it can get started. Typically, the way some of the first stages include stakeholder engagement, stakeholder outreach. That's typically a required step in most instances, but it includes collaborating with people from the industry and other interested parties to discuss any rule changes, amendments that may be proposed. This can include meetings, discussions, filed comments, other exchanges, a variety of ways that can be accomplished. There are, just FYI, exceptions to that step in the process for things like temporary and emergency rules. So just be aware of that if that's the way the commission's going about a particular rule change. Based on the information that's typically received through the stakeholder process or other information, the Notice of Proposed Rulemaking, or NOPR as we call it, the decision gets drafted that essentially initiates the whole process. This decision is typically pretty thorough and includes an outline of all the proposed rule changes that are going to be part of that process. The NOPR indicates specific topics also, or ideas for exploration, and usually will encourage stakeholder feedback on some of those ideas when that's the case. Transportation staff or commission staff will work with the Attorney General's office on this sometimes, and usually either staff or the Attorney General's office will put together the draft of that. The Attorney General's office, which is the basic representation for the commission, they offer important legal direction for us, so that's one of the reasons they're involved. After the NOPR is issued, which is public information at that point, the proceeding is then typically referred to an administrative law judge, or ALJ. The ALJ would then manage the entire process of the rulemaking, including public comment periods, public hearings, and ultimately they're responsible for issuing a recommended decision that will adopt, or maybe even not adopt, the new or amended rules. There are instances when an ALJ may not run the process, but instead maybe one of our commissioners may act as a hearing officer, but that's pretty rare. There are normally designated comment periods where it's suggested that stakeholders file written comments regarding their position on the proposed rule changes or their desire to explore other related rules. People do have the right to file the comments at any point during the proceeding, but it's usually good to follow those timelines because they're designed to keep the whole process on track. And if a comment gets filed way late in the process, it may not be able to be considered to the same amount had it been filed earlier. So just keep that in mind. The deadlines are usually something like a week or two before the scheduled public comment hearings, typically. Speaking of the public comment hearings, these are scheduled so that stakeholders and others can add testimony to the record, which will be considered by the ALJ or the hearing officer when drafting that recommended decision. These can become pretty lengthy and consist of many hours of testimony, which could extend into several days and even necessitate the need to schedule another hearing at a later date and time. Any of you who may have participated in this recent towing NOPR knows that there was 4 public comment hearings, so it kept getting extended out because issues kept coming up. So that can happen, and that's all part of the process. During these hearings, commission staff typically are present to answer any questions that might come from the ALJ or the hearing officer, or to respond to any arguments that may come up as part of that discourse. Commission staff are typically considered subject matter experts, or SMEs, so their input, input offered by staff is usually given some weight alongside everything else that's being discussed. After all the public comments, testimony, and other filings have been considered, the ALJ or the hearing officer will issue what we call a recommended decision. Depending on how much information is in the record or how complicated the issues are or were, these decisions can take some time to come out, but they're due within 180 days after the last public comment hearing was held. These decisions are usually very thorough and outline all the accepted rule changes or accept various rule changes and amendments for adoption, including the justification and legal basis for these changes. The decision becomes the basis for the rulemaking and affects all the actions that occur after that. After the recommended decision is issued, people have 20 days to file what they call exceptions to any or all the determinations made in the decision. Pursuant to state statute and practice of procedures, Rule 1505, in order to file the exceptions, the party must request transcripts within 7 days of the mail date of the recommended decision, unless the party's exceptions disputes only issues of law. So just be aware that to file exceptions, you may need the order's transcripts. Regardless of whether or not exceptions are filed, there's still that 20-day waiting period after the recommended decision is issued before you can move on to the next stage. If no exceptions have been filed, or if exceptions were filed and subsequently addressed by the commission, the decision then becomes a commission decision, and parties then have an additional 20 days to file what they call an application for rehearing, re-argument, or reconsideration, or triple R. If no triple Rs have been filed, or triple Rs were filed and were subsequently addressed by the commission, the decision then becomes a final commission decision, and the process moves on to the Attorney General's office opinion phase. So that stage is the AG's office has 20 days to file their opinion on the new and or adopted or amended rules. The opinion is submitted to the Secretary of State, and it's also filed within the proceeding itself. After that AG opinion has been filed, the commission is responsible to publish the rules, which it does through the Colorado Register, which publishes on the 10th and the 25th of each month. After being published, there's another 20-day waiting period before the new amended rules can become effective. In regard to all these 20-day deadlines, just keep in mind that if the 20th day falls on a weekend or a holiday, the 20th day moves to the next business day. So just be aware of that. Also, keep in mind that the commission can always become involved as it pertains to a recommended decision. If they see something, they feel a particular way about, they can stay the decision or order additional actions to be taken by the ALJ as the situation warrants. They can also extend any time periods as outlined in the procedures. So all things being considered, this outlines just how long these rulemaking processes can take, just to go through all these different stages. So again, notwithstanding the amount of time it takes just to get to the point where a recommended decision has been issued in the first place, which again can take months or even years. The towing NUPR, for example, was started in February, and here we are in October. There's still probably going to be about 3 months until the rules can become effective, even after the recommended decision was issued. And that's assuming there's no exceptions or triple Rs filed. So just in general, be aware that it is quite a process to kind of get through it all. And yeah, just be conscious of that, because I know people can get a little frustrated with how long it takes sometimes. And we just want to make sure that people understand, we are bound by this process, and we do everything we can to make it go as smoothly and as quickly as possible. But again, because of all the due process provisions and everything else, it just is a process that takes quite a bit of time to accomplish. So moving on from rulemaking to legislation, just wanted to, I'm sure what everybody wants to talk about is House Bill 22-1314. That's what's been on everybody's mind for the past year plus. So we'll talk about that quite a bit here today. But just so everybody understands how this all happened, House Bill 22-1314 was passed last year during the 2022 legislative session. It was signed into law on June 7th of 2022, but it actually didn't become effective until August 10th of 2022. So it's been in place for a little over 14 months now. So just so everybody understands the timeline. What the bill did, most notably, was made significant changes to the non-consensual towing in Colorado, more specifically to the residential private property impounds. We'll get into the distinction between residential and commercial here in a minute. But yeah, just so everybody understands, most of what the bill did, not all of it, but most of what it did, was affect how PPIs are handled when the origination address is a residential style private property. That's what most of the bill covered. So moving on to this distinction between residential PPIs and commercial PPIs, it's mostly what it sounds like, which is if a towing carrier is towing a vehicle that's originating from a residential style private property. So maybe it's an apartment complex or condominiums or some type of an HOA type association, residents, things like that. Those are clearly more residential properties. And so a lot of the new standards that came in as part of the House bill last year are going to apply to those circumstances. Commercial PPIs, on the other hand, those are, again, exactly what it sounds like. It's more commercial style properties. Maybe it's Home Depot, maybe it's a Wendy's parking lot, things of that nature. So just understand that, due to the legislation that was passed last year, there is that distinction now between those types of tows and the requirements that go along with each type. So just be aware that there is a distinction there. Most of what you're going to find, where you're going to find that distinction is under that statute listed there, 4010.1405. That was probably the largest part of the bill from last year, was the creation of this new 405 statute. A lot of the new provisions that went in there, a lot of the new consumer protection style items that you've heard about over the past year plus, typically are going to fall under that 405 statute. Not all of them, but most of them. So definitely encourage you to read through that statute. It consists of 9 subparts, so 405.1 through 405.9. Just make sure you read through those and kind of understand the distinction. But again, because of the 405.9 applicability provision, you just want to understand that a lot of what they put into 405 is not going to apply to the commercial PPIs or the law enforcement ordered tows. So just understand that there is that distinction. And also the distinction between residential and commercial PPIs doesn't apply across the board. There are some things that got changed as part of that bill last year that does not apply to one or the other, but rather both. So for example, the storage limits, and this was actually a change they made under the 42.4.2103 statute for statutory notification. And what they indicate is that when it's a private property tow, not residential, not commercial, just private property, so both, then you actually can only charge for the first 24 hours worth of storage until that statutory notification process has been completed. So just be aware that there are some provisions of the bill that applies to both categories of tow. And even though a very large portion of the bill applies mostly to just the residential, there are those provisions in the bill that apply to both. So just be aware of that. So just kind of an overview of how legislation works. So this is an outline that we pulled off of the legislature's website. I think it's a graphic that they came out with back in 2001. So as you can see, there's not really much that's changed in regards to the process over the last 20 or plus or so years. So just kind of a quick summary of how legislation happens, in case you're not already aware. So bills can start in either the House or the Senate. A bill is introduced to the entire, the bill is introduced to the entire body and gets what they call a first reading. And then the bill is referred to a committee. So there's different types of committees, which are usually pretty similar between the House and the Senate. So for example, you have committees on finance, business affairs and labor, health and insurance, transportation and local government, education, judiciary, appropriations, a lot of different committees. There's sometimes subtle differences between the Senate and House committees, but for the most part, they address a lot of the same categories of things. During the committee hearings, the bill is heard, discussed, and voted upon. At that stage, there's typically verbal testimony from experts and constituents and other interested parties. Amendments to the bill can also occur at that stage. If the bill is passed by the committee, then it goes back to the body, so either the House or the Senate, depending on where it was first introduced, for a second reading, which may include debate and amendments to the whole body or the committee as a whole, as they call it. The bill, if it's passed on second reading, will then go to third reading final passage, which again may include additional debate and amendments. And depending on the nature of the bill, how hot a topic it is, all that, those debates can last for hours or even days sometimes. So it just depends on what's going on. The bill, if passed on third reading, then gets referred to the other body. So bills that start in the House would go to the Senate and vice versa. The process then mirrors the other side, with the bills being assigned to committees, second and third readings, potential debate and amendments, all those stages. If the bill passes the other body unamended, then it's considered passed and goes to the governor for signature. If the bill passes with amendments, it goes back to the originating body, so whether it started in the House or the Senate, so that they can either accept or reject those amendments that come from the other body. If amendments are accepted, then the bill is considered passed and goes to the governors for signature. And if the amendments are not passed, the bill can be referred to a conference committee, which is comprised of members of both the House and Senate to try to come to an agreement. If an agreement is reached, a report is sent to both the House and Senate for approval, and excuse me. And if approved, the bill is considered passed and goes to the governor. Once the governor receives a passed bill, they can sign the bill, making it law as annotated within the bill. There is time limits on this, so 10 days during the session or 30 days after the adjournment. If not signed or vetoed during that time frame, the bill is considered becomes law as annotated in the bill. If the governor vetoes the bill can still become a law if both the House and Senate repass the bill with a 2/3 majority of all members. And some bills include what they call a referendum clause, which means the bills passed that way have to go to the Colorado voters for a vote. Some bills also include what they call a safety clause, meaning that it's effective upon signature or whenever the bill becomes law. And then some bills include a provision that's act subject to petition, which is what the House bill from last year was, which means that within 90 days after adjournment of the General Assembly, a referendum petition can be filed, which would make the bill effective upon vote of the Colorados at the next general election. Even though that had that clause last year as part of the House bill, that was not done. So that's why it became effective on August 10th, even though it was signed back in June. So just so everybody understands, that's why it happened that way. Also, just in general, when it comes to legislation, keep in mind that DORA, so our parent department, as well as the PUC itself, we do have restrictions on how we can engage in legislation, which is based on department policy. So nearly everything typically needs to go through our legislative liaison. So if you want to call and talk to us about legislation, we may not be able to with you. So again, that's all just based on department policy. So just be aware of that and just understand our position in those situations. And of course, we encourage you to participate in your legislature. So, if you choose to engage in your local representatives, whether it's your local representative or senator, we encourage you to reach out to them if you're seeing issues or there's particular things you'd like to see addressed in the statutes. Definitely encourage everybody to do that. So the last part of our training is new standards and requirements. So this is just kind of an overview of some of the things that changed as part of the House bill from last year, which I'm sure you're all interested in. So this is a summary we came up with shortly after the bill was passed that has been on our website ever since. It's right there on the towing webpage. There's a link to this document. And this is just a cutout of that particular document. It's not the whole document, but it's the part we wanted to discuss today. So this essentially highlights kind of the bigger features of House Bill 221314 from last year. And we'll go through all these just so you all understand exactly what they are and what they mean and kind of what our expectations are as it pertains to these different pieces of the bill. So one of the big things that I'm sure you've all heard about and you've been dealing with over the past year plus is the 24-hour notice standard. So 24-hour notice, again, this is one of those pieces that applies to the residential PPIs. And basically the standard is that by default, 24-hour notice needs to be provided basically before a non-consensual tow can occur. Now, there are exceptions to that, which we've listed them here, or at least some examples of them, which includes things like if a vehicle is blocking a driveway or a roadway enough to obstruct access, that's one where that's an exception to the 24-hour notice standard. Improperly parking in a handicap space is another exception. Parking in a designated and marked fire zone is another example. Improperly parking in someone else's designated space. So if at a particular private property, somebody like rents or leases a particular like numbered and specific exclusive space for them, and somebody's parked there without permission, that's another exception. Or improperly parking in a permit-only area. And then also continuing to park inappropriately. So if you've given multiple warnings, that's another exception to that standard. Let's see, moving on. Towing company must release a vehicle upon request and without fee if they have not left the private property. So again, this is another one that's a residential PPI process or standard. And basically, it's the same process as before for the drop fees and charges. It's just for the residential PPIs, you can't charge for it anymore. So just be aware that that is a restriction that was put in by the statutes last year. Moving on to the fourth bullet point there, the towing company must take photos of the vehicle's condition and of the reason for the tow before removing it. I'm sure a lot of you were probably already doing some of that because there's a lot of instances, especially in our investigations team, where we get photos of tows before they occur. So I'm sure a lot of you were probably already doing that before, but they went ahead and put it in statute where now it's a statutory requirement. So basically, it splits into two different requirements, which is one, You have to take vehicle pictures of the condition of the vehicle. So basically from all four sides of the vehicle, so both sides, front and back. So that's for a total of 4 photos, as well as, and the second thing is the reason for the tow. So just be aware that that is a requirement. So, for example, if you were towing it for having a flat tire, for example, which is against the parking policies of that particular community, you'd have to take a picture of that flat tire and basically say this, indicate this is why it's being towed, is because it has a flat tire, which is in conflict with the parking policies. So that's just an example, but it could be other things. If it's in relation to a sign, for example, so like say for the fire lane one, which is an exception to the 24-hour notice standard. If somebody's parked in a designated and marked fire lane, and there's the fire lane sign right there saying don't park here, just make sure that your photo includes that signage, because that can be a problem if you don't capture that. So just be aware of that. All right, moving on to expired plates. So this is something that the commission already had a rule about in some way under 6508C, but this kind of made it a little more clear within the statute, which is again for residential PPIs, you cannot tow a vehicle for the sole purpose of it having an expired license plate or registration. The only exception to that at all within the statute is if that particular tow is authorized by a law enforcement officer. That's the only exception. So just be aware of that. Towing companies cannot charge vehicle owners storage fees except for the first 24 hours until the vehicle owner has been officially notified. So I know we just talked about that a minute ago, but I think it's a big point and worthy of discussing again. So again, you tow a vehicle, and again, you can charge up to that first 24 hours of storage, but in the background, you're still doing the statutory notification process. And essentially, after that first 24 hours, you have to put those storage charges on hold, and they can only restart once you finish that notification process. So you've run your searches, you've gotten your results, and the letters have gone out. Then you can restart the storage charges. And again, that's pursuant to the changes they made in 42.4/2103. So that's for all private property tows, not just residential or commercial, for both. Towing companies have to display the maximum rates as designated by the commission at their place of business or on any website. That's also a residential PPI standard. So basically, and that's one of the reasons why, as part of our tow rates available on our website, we turned it into a nice printable one-pager for you. So all you have to do is print that off and post it at your place of business. So hopefully we've made that easier for you. I know they weren't always posted that way. We were doing it as part of a spreadsheet in earlier years. But based on the feedback I got, we made a commitment to make it a lot easier for y'all to just print it off and post it somewhere. So we went ahead and did that several months ago. So hopefully you all have found that a lot easier to deal with. But yeah, make sure those are at your place of business. So at your storage yard, wherever. And also on any website you might have, just if you can scan a copy and put it somewhere on there, or you can just take the information on there and put it in there yourself, as long as they're displayed. Towing companies must release the vehicle's contents within 30 days of the official notification. So this is kind of a standard that the commission's been playing around with for probably the last 5 or so years. And basically, there's been a lot of feedback over the years about consumers not being able to get their personal property out of vehicles after they've been towed, unless they just get the vehicle out altogether. Obviously, we've had the standards under Rule 6512 dating back as long as I can remember on the protected items, which is things like medication and child restraint systems, medical equipment, cell phones, identification, federal state identification, wallets, those types of things. Those have always been on the protected list, and that hasn't changed. But in regards to somebody's personal property, so maybe they had, work boots or, work tools or, something of that nature, just anything that's not part of the equipment of the vehicle or is part of the vehicle itself constitutes personal property. And so previous to the legislation from last year, that's something the commission had been allowing through the rules, and essentially was allowing towing carriers to essentially charge the hook fee to release that personal property to these individuals. We're trying to essentially structure something similar now, through the pending NOPR that's going on right now, where you can essentially still operate in that same way for both commercial PPIs and law enforcement PPIs. Now it's going to refer to the particular rules and fee structure attributable to those types of tows in Rule 6511. But that's essentially how we're setting it up. Is you can essentially charge the hook fee for PPIs or the hourly rate for law enforcement ordered tows for the release of personal property. Now, the trick here is based on the statute that was passed last year. For residential PPIs, you can't charge anything. So essentially, we're setting up this new structure under Rule 6512 that will direct you based on the type of tow you're performing and where you're towing it from, which will explain to you exactly what you can charge, if anything. So that's the way we're structuring or attempting to structure those new rules. So that's essentially how it's being treated right now. And then finally, and probably one of the things people have talked about the most over the past year is the people refer to it as different things. I probably for the most of the last year or so, I've referred to it as the release without full payment provision. Other people refer to it as the 15% $60 provision. Some people have even referred to it as reduced fee provision. I guess there was some confusion about calling it a reduced fee provision just because that kind of people can infer from that somehow they're getting some kind of a discount on the overall released fees, which is not technically the case. They still owe the full balance. It's just they're getting it released for a lesser fee on the front end is how it works. But anyway, I'm sure you all know what I'm referring to is this new provision. So essentially the way the statute is set up is a vehicle that's towed, again, as a residential PPI, has to release the vehicle when an authorized or interested person comes and is willing and able to provide 15% of the overall fees, not to exceed $60. So, if it was a $300 bill, it's whatever 15% of that is. But if it was a $1,200 bill, for example, 60 is the max that you can charge for that. But if that amount is paid, and they sign the form that's available on the commission's website that we've designed for this process, then the towing carrier has to release that vehicle to them at that time. Basically no other, there can be no additional conditions for release on top of those two things is essentially how it all boils down. So I know this has been a topic of extensive discussion and debate as part of the pending NOPR process. But I'm sure you probably, or at least most of you have probably seen that the recommended decision in that rulemaking has been released. It was released a little less than a week ago. So I hope you all had a chance to review that and the accompanying red line rules that kind of constitute exactly how we were attempting to integrate all of the new statutory mechanisms into the current rule structure in a way that would be a lot easier for you all to understand. So anyway, that's something that is currently in effect as a statutory provision. And what we're doing as part of the rulemaking process is, again, just integrating all these different aspects of the statutes that were passed last year and putting them into the current rulemaking structure and regulatory framework of the towing industry based on the commission's rules. So, yeah, anyway, that's kind of how it's set up, and that is what the expectations are. So that's most of what I wanted to go through today. Let's see, we're about 50 minutes in, so we definitely have plenty of time for Q&A. Before we get to that, though, I just want to share all of our contact information here with all of you. So feel free to, just take a quick picture of this on your phone or whatever, or write it down. But yeah, this is our contact information here at the commission. So our main number is 303-894-2000. So that gets you just the main commission number. I think transportation is option 4 when you get to the prompts on that main number. You also have our consumer affairs and complaints team, which is, we just refer to them as consumer affairs, but they're the ones who take all those initial complaints. So if you need to reach out to them for whatever reason, maybe there's a current complaint ongoing and you need to talk to them for whatever reason, you can call 303-894-2070, or maybe you want to file a complaint yourself against someone else. That's fine. You can use that same number. Myself, again, Nate Riley, I'm the section chief here for transportation at the PUC. My number's here as well, 303-894-2848. Lloyd Swint is our investigations supervisor, and his number is 303-894-2263. So if you have any questions for investigations or investigation-related enforcement questions, feel free to give him a call. He'd be happy to speak with you. And our address is 1560 Broadway, Suite 250 in Denver, Colorado. So we're kind of catty corner from the Capitol building. And then emails. I put myself and Lloyd's emails on here. So for myself, it's Nate, N-A-T-E, .Riley, R-I-L-E-Y, at state.co.us. And then Lloyd Swint, L-L-O-Y-D .S-W-I-N-T at state.co.us. So that's our contact information. Feel free to reach out to us anytime on any topic. We're always happy to talk to you about any of this stuff. So at this time, I'd like to go ahead and just open it up if anybody has any questions or comments. I know we went through quite a bit today. Again, as a reminder, just in case anybody popped in here late, we do have additional training seminars that we've planned for upcoming months. So again, November 17th, which is a Friday. So it's 2 weeks from this coming Friday. Same time, 1 p.m. start time, and the topics we'll be covering is administrative overview. So we'll talk about the permitting process, some other regulatory framework concepts, and some other things. And then December 8th, which is 3 weeks following that next one, also a Friday, also 1 p.m. start time, which we'll be talking about complaints, investigations, and enforcement. So again, I definitely appreciate everybody being here for this. This is a new training regiment we're trying. So we're hopeful that this will get out here. Oh, one other thing, just so everybody's aware, we are going to be posting a recording of this particular training on the website at a later date and time. So feel free, we'll probably put it somewhere on that main towing page somewhere. So just keep an eye out for that. If you think somebody else in the industry would benefit from this, would encourage them to participate or to go and review the recording and kind of hear some of the things we reviewed and talked about today, just in case they're interested or you think it would be helpful to them. We're also exploring some other training requirements as part of just the towing industry in general, maybe part of the permitting process or something else. But yeah, so that covers pretty much everything I had on the review today. So again, if anybody, we got about 30 or so people in here. So if anybody has any comments, questions, concerns, feel free to shout them out. You can just jump in, or like I said, if you want to use the raise hand feature, that's another way I can see that you want to say something.
Nate, this is Stephanie with M&H Towing in Montrose. I was at the training last week over there in Denver, and I know we kind of talked about that, but can you just review real quick for me abandoned vehicles in our yard of, like, I know we talked about that was like it was like a stop point and then a restart point. So do we need to have like two separate invoices? Do we need to do like the pictures of, like, because we're not really towing it again, it's just in our yard and abandoned after either a law enforcement tow or a consensual tow, and then it's not been picked up for whatever reason.
Sure. So just so everybody's aware, and I remember this conversation from last week, so thanks for raising it again. So just so everybody understands what we're talking about is a situation where you essentially engage someone in a consensual towing situation. And as part of that service, you are essentially taking it back to your storage facility and storing it for this person. But for whatever reason, you can't get in touch with them. They've essentially just left you with the vehicle, and now it's stuck in your yard. You don't want to hold it there forever. And basically, what's the best solution from that point to remedy the situation? So again, because it initiates as a consensual tow, there's very little operational standards that you need to follow, just because consensual towing here in Colorado, and actually in a lot of other states in the country, is just not very very regulated for the most part. In a lot of states, including ours, we usually require permitting, insurance, equipment, some type of equipment threshold, and fee disclosure. That's really the four major components that we require for consensual towers, is those four things. So as long as you're doing all those four things, there's not really a lot of oversight over exactly like how you're running things outside of those four things. So in that type of situation where basically you now have a vehicle that's essentially unclaimed, it was towed as consensual. So again, you're meeting all those four requirements, but it's like, what do I do with the vehicle now? So at that point, kind of the way we've suggested could be a way to navigate this process is to essentially deem the vehicle as basically pick a point in time and say, okay, if I don't hear from them by next Friday, I'm going to deem the vehicle to be abandoned, and I'm going to follow all the typical private property impound abandonment procedures, which includes notification, which includes a law enforcement call, which includes, making sure you're following the correct maximum fees and charges, all of the other things that go along with as if it had been towed right that moment from a private property, and you're bringing it back to your yard. Now, of course, you're not going to be able to charge for a tow because you actually haven't moved it anywhere. It's just where it was all along, which is in your yard, essentially. But yeah, you definitely want to separate it. You essentially want to close off the consensual part of it, which you can pursue, in whatever way you typically would, whether you sue them or go debt collector or whatever you want to do to collect that outstanding balance on the consensual side. But you've now turned it into essentially a non-consensual tow because you're essentially holding it kind of without their consent, in a way. So, and you would just follow all the other procedures that you normally would, had it been a PPI from the start. But again, having that distinct separation between the two processes is key to that situation because you're essentially closing off that initial part of the tow and initiating what would be a new action is how we view it. Does that answer your question?
Yeah, I think so. Thank you.
Rhonda, I saw your hand was raised. Did you have another question? Okay. Does anyone else have any questions? Again, we got about 30 people here, so I'm sure there's a lot some of you might want to talk about. And we are ready to answer whatever questions we can.
Can I ask, does it have to be just about the legislation or can it just be general questions?
At this point, I think we can open it up to kind of whatever. But one other thing, just to kind of let everybody know that, and I know I kind of explained this a little bit earlier, but yeah, what we've done as part of the current rulemaking process, and again, it's still pending. There's nothing's been finalized yet. We did have that recommended decision come out last week, which I would encourage all of you to read. It's long. It's about 50 pages long. So yeah, you're definitely in for a read, but there's a lot of good stuff in there to read and kind of see where the commission is coming out, at least initially. So, but again, things can change between now and when the rules actually become effective, which probably won't happen until sometime early next year. But just so everybody understands, our key goal as part of that rulemaking process was to integrate all the new statutes. That was priority one, and to kind of clarify in the areas that we thought needed a little bit of clarification. So, and again, also to integrate it in a way that would be the most palatable to the towing industry, because again, if you just read through the bill and the statutes, when you do a side by side with our rules, certain parts tie to other parts, and it's kind of all over the place. So we try to integrate it in a more straightforward way, just going down the list and separating it into all the appropriate areas, like authorization, tow invoice requirements, fees and charges, release procedures, signage, all that. We essentially took it from the bill and put it all in the appropriate areas based on what subject the particular statutory provision was referencing. So whether it was a signage requirement or an authorization requirement or a tow invoice requirement or anything else. So something else some of you may have heard about is that it sounds like and this is based on news articles and stuff that have come out in the recent months. It sounds like they may be gearing up to do some more towing legislation in the coming 2024 session, and that's fine. We'll adjust the rules again if needed, because again, our rules are going to be set up in a way that would integrate whatever the current statutory provisions are. And so right now we're updating them as part of this current NOPR process to integrate the changes that were made last year. So if they change the statutes again in a way that is different from what they passed last year, that's fine. We'll readjust them as we can. So I mean, we're always changing our rules. Sometimes we'll have several rulemakings in a single year. That's not unusual. So we kind of take it as it comes. So that's the plan. If there's legislation that's passed again here in the coming year, then we'll react to that in the way that we always do. But yeah, Stephanie, if you had a question on something else, feel free.
So I know this came up again, and we didn't really touch on it during your presentation, but we had it kind of asked as far as from a law enforcement perspective. We're having some pushback from a couple of our local agencies as far as when they start the paperwork of when a vehicle is deemed abandoned, as far as when they need to send out the paperwork. And then also if it comes to our yard, like whether or not that is a law enforcement ordered tow that we need an impound sheet for, or if the owner is on scene and makes those arrangements with us, is that considered then just a private tow between us and the owner? Hence, that's where we end up in these situations where they're left in our yard and we never see or hear from anybody ever again. But I mean, that doesn't happen all the time, but occasionally. But our biggest one is with a situation that we have right now with our local state patrol office, that the guy in charge of our impounds is saying that it's a matter of when the vehicle is deemed abandoned, and he's kind of arguing of who gets to make that decision of when it's abandoned.
Sure. Yeah, and that can be a tricky situation to navigate at times on whether or not you are considering a particular tow to be consensual versus a law enforcement ordered tow, especially when you're dealing with roadsides and things like that. I would say if it's becoming a complex process and all that, I mean, I'd make sure first off that you're on the same page with whatever law enforcement agency you may have been called out on rotation. And make sure you understand kind of what their position is on all this, because again, how their officers or sheriff deputies or troopers are going to respond will kind of in a way dictate how you're going to react. So I would make sure first off that you're on the same page with that law enforcement agency, whoever they are, that you understand their position and kind of how they're viewing things, so you can kind of play off of that would be the first step. And secondly, you can always refer to, our definition of a law enforcement ordered tow, and it basically boils down to, and this isn't the exact language, but kind of the concept that is derived out of that rule is if the vehicle owner has and retains sole discretion on what happens to the vehicle, then it's typically going to be considered consensual. However, if they're ever at any point during the process in a situation where it's no longer their decision to make, and say the officer, for example, says, "Oh, well, this is just what's going to happen," then at that point, that authority from them has been removed, and so it falls more under law enforcement order, because again, they didn't make that decision. They wanted to do maybe something different, and they couldn't, essentially. So those are probably the responses I would give to that particular question. But yeah, I'd start with the law enforcement agencies and make sure you're at least on the same page with them, so that you're both kind of understanding in these situations kind of which way it's tilting is kind of how I would describe it.
But who makes that decision as far as I mean, it's in the Department of Revenue regulations, or it's in the PUC regulations as far as that 2 to 10 business days of when that notification needs to be mailed out?
So those are Title 42 statutes. So again, if we're talking about public property tows, which it sounds like is kind of the case in this particular scenario, then again, you're going to want to refer to 42-4-1804 because that's going to outline exactly how that's supposed to play out. Now, if on the opposite side, it kind of seems like law enforcement ordered at first, but then it actually is a consensual tow, then there's no notification standards because at that point, you're essentially towing it with the authorization of the vehicle owner or operator. So you don't have to provide notice. You would only have to provide notice if later on down the line, again, it was towed initially as consensual, or at least your understanding of it was towed as consensual. And then later on, you're like, this person's no longer around. I can't get in touch with them. They've essentially just left me, saddled me with this vehicle. I can't do anything with it. What am I supposed to do? And that's where I would go to my earlier comment about, I think it seems that there's enough cover under the statute to essentially separate it and close it off as a consensual tow and then deem it abandoned on private property, the private property being your storage facility. And then essentially moving forward with that process, which would require notification, both local law enforcement 30-minute notification, as well as the actual statutory notification, running the search, sending out the letters. So it seems like you're in control of when that might happen. Again, this is all assuming there's not like holds or anything on the vehicle. That obviously puts a spin on all this. But if that's not the case, and you've just essentially conducted a consensual tow, and then for whatever reason you can't get this person to call you back or whatever, and you're like, okay, I'm only giving it till next Friday, and then I'm going to deem it abandoned on my property, then that's going to trigger all of those accompanying requirements. So as long as you understand where that switch is, and it's clearly you're able to demonstrate it through your paperwork that this is when we converted it from a consensual tow to a non-consensual or an abandonment, essentially.
Okay.
So as long as that's clear, then you're probably setting yourself up in the best situation, considering what's going on.
Well, and I think where State Patrol is coming from is like if it was so the situations that we've had on the last few cars that we've towed in for them that they seem to be taking forever to get us our paperwork is that it wasn't abandoned on the side of the road. We didn't have anybody there. So it was truly a law enforcement tow. And then somebody calls and finds out that we're the ones that have it. They call us to see what the process is. The trooper is now telling us that if they've been in contact with us, he doesn't have to send out that paperwork. And it's up to us whether or not we agree to, well, I don't get paid till next week. And so if they don't show up next week, then we can start the process. And that's not how we interpreted it, but because they could call every Friday and say, well, I can't pay this week, I'm going to come next week. And this could be a 6 or 8 month process before we ever deem it abandoned according to what he's saying. And so that's where some of that question came up on Wednesday when Bill was doing his presentation, and he happened to be at our yard when Bill was there. And so he was on a phone call with me asking those questions and kind of arguing with us of who gets to determine that date of when that paperwork process gets started. Mm-hmm. And in regard to that, like part of what started this whole conversation with them was I got pushback from Department of Motor Vehicles when I went in to take paperwork in, and they told me essentially to begin with that they weren't going to give me title work on vehicles because it was beyond the 60 days from the date it was towed. And I'm like, well, law enforcement just gave us our paperwork. I don't have any control over that.
Sure. Yeah, and I think we look at it in a similar way here at the PUC. I mean, there are statutes, especially in Title 42, that apply to an industry that we regulate, the towing industry. But it also applies to, like law enforcement agencies in regards to, for example, under 42-4-1804, it says that the operator, which is the towing carrier, has to do the statutory notification process along the statutory timelines. It also says the law enforcement agency has to do it. But if they weren't to do it, there's nothing the PUC could say about it. We don't have any jurisdiction over that law enforcement agency over what they do or don't do. So it can throw a wrench in things at times, I agree. But I mean, I know we're limited in that way. I assume DOR is as well. And so, I mean, we can really only do the best that we can to make sure that what we can control, which is the towing carriers, are doing everything that they can to, again, make that good faith effort to comport with what the statute is telling them to do. All right, we do have a couple of chat comments, so I'll go ahead and read these out. So this is from Rhonda. On the last part of the meeting regarding PPI, does commercial PPI include that 15% release or $60 fee? No. It's one of the standards that is in the 405 statute. And again, one of the key components in understanding that statute and what it actually does is understanding the 405(9) applicability provision, which says it doesn't apply to essentially commercial PPIs and law enforcement ordered tows. So and we've gotten a lot of calls on that over the past year plus where, we'll get a call from a towing company that, somebody comes to collect a vehicle and they're going on and on about this new provision and, hey, I only have to pay such and such amount. And my first question every time when I get a call like that is, where did you tow it from? And in a lot of cases, it's like Home Depot, Wendy's. It's like, that's clearly a commercial PPI, so that standard doesn't apply. It's pretty clear in the statute. It's just for residential PPIs. So that's the answer to that question. And then we have another one. Can you go over what has to be released from? Can you go over what has to be released for private property for law enforcement ordered tows, or are those items staying the same? So if you're talking about protected items, which is, again, there's a list of them, but it's things like prescription medication, medical equipment, child restraint systems, let's see, federal and state identification, cell phones, money and credit cards, if it's going to be used for immediate payment for release of the vehicle. There's items that have been part of our 6512 requirements for as long as I can remember. Those are, we call them the protected items. So those are things towing carriers have never been able to charge to release, regardless of if they're getting the vehicle out or not. If those vehicles are contained within the vehicle, then you essentially have to release them at no charge. That's always been the case. If you're talking about personal property, we are applying that standard to essentially across the board. And it's something the commission was kind of already doing anyway, at least for non-consensual tows and for law enforcement order tows. So we just took the consideration into account that per the new statutes, you can't charge for the release of personal property for residential PPIs. So we essentially carved that out and said, yeah, you have to release personal property to an authorized or interested person that comes and requests it, essentially, as long as that is done within 30 days of when so that requirement starts when the vehicle hits your yard, and then it continues until 30 days after statutory notification went out. So it kind of follows the same timeline as the appraisal statute under 42.4/2104. Which basically says 30 days after statutory notification. That's when that triggers the next all the subsequent stages of the process, where you subsequently apply for title and sell the vehicle. So it follows the same timeline and basically says if somebody comes in that can demonstrate that they're a authorized or interested person, and they essentially have right to the vehicle in that regard, then personal property has to be released to them under one of two things. If it's a residential PPI, you can't charge for that. It doesn't matter if they're getting the vehicle out or not. You have to release that personal property as long as they make the request within that window. Outside of that, I think is a different conversation. But as long as they're asking within that window and it's a residential PPI, you have to release the personal property, and you can't charge for it. Now, if it's a commercial PPI or a law enforcement order tow, you still have to release it in that window. But for a commercial PPI, you charge the hook fee for that. And for the law enforcement order tow, you charge the hourly rate for that. So you can charge for it. But it's only residential that you can't charge for it. And that's pursuant to statute. So I think that answers that question. Let me know if I didn't. All right. Okay, yes, that answers the question. Thank you. All right, any other questions? We're about a quarter after, so 2:15. So we've been going for about an hour and 15 minutes. But yeah, no, I feel good about this first training. I think we covered a lot of good information, and I definitely hope everybody participates in the other meetings we have scheduled. Again, November 17th, 1 p.m. for administrative type items. We'll be training on that. And then December 12th, 2000, December 8th, December 8th, also 1 p.m. Those are both Fridays. And we'll be covering complaints, investigations, and enforcement. So, and we'll probably have people, other people from our transportation team on both of those other meetings. So we'll have some of our experts here to talk about, like administrative. We'll probably have some of our people that process our applications and stuff here to answer any question, more specific questions that come up. And then for complaints, investigations, and enforcement on December 8th, we'll probably have some of our investigations team participate in that as well, so they can answer some questions.
I have one question.
Yeah, sure.
This is Rochelle from Elliott's. I've been having trouble getting registered owner information from vehicles that are registered in California. Is there a way that people or other tow companies or you recommend that I get that information? Because sometimes I know there's a registered owner, but California just will not release it.
Mm-hmm. So as long as you're, are we talking about private property tows or something else?
Either one. So
okay.
It just in general, any vehicle that's registered out of California, I'm having trouble with it.
Okay. So my understanding, and I'm sure all of you are aware of this, but just to reiterate, the way the process works for statutory notification is for private property tows. It's slightly different than for public property tows, but it's still pretty much the same process for the most part. There's some differences based on what they'd made changes to last year, but for the most part, it's still mostly the same process, which is you run the search. For public property tows, it's still 2 to 10 days, but for private property tows now, it's just within 10 days. So they eliminated the 2-day waiting period. So you run that initial search, you do your IDS, and if it has a hit, then you do your letters and you send them out and you're done. That's the process. And just remember, everybody, you got to send it to any and all people that are listed on that IDS search. So if it's like 2 owners and 1 lien holder, you're sending out 3 letters. So it's got to go to everybody. So just be aware of that. Same thing with multiple addresses. If it's 1 owner but 2 addresses, send it to both. Like that's just the best way to cover yourself. If you run the IDS search and there's not a hit, then it automatically triggers the national, which is what DOR does. So DOR does that national search for you, and then they come back. They let you know one of 2 things: either yes, we have a record, maybe it's out in Virginia or Montana or wherever. And they say here's the information. Again, you do your letters, and you're done. The other option, which is the most unfortunate one, is you don't get a hit on the IDS, triggers the national, no hit on the national either. And if that's the case, the process is essentially over because there's nowhere left to go. There's nothing else in the process that determines what the next step is after that. So that is essentially the end of the process. And that's how we've always treated it. So if you elect to do anything beyond what I just described, you are absolutely free to do so. And we would even encourage you to do so, especially if it's something where there's something that could be there. And I mean, there's different things I've heard from towing carriers over the years on what they've done. So for example, maybe if they don't get a hit on the IDS or national, at that point, they've met their statutory obligation, but maybe they reach out to the property owner and maybe they know who they are. And, you don't have to do anything so official like certified mails or anything, but because at that point, you're just doing extra stuff on top of what you're required to do. But again, we absolutely encourage that because again, you're dealing with somebody's property, and I think every effort should be made, even beyond what you're statutorily required to do, to try to contact that person and let them know you have their vehicle. So that's always been something I've encouraged, and I definitely compliment you for wanting to go that extra step. In regards to California itself and their reluctance to provide information, I mean, I'm not sure if there's anything you or even I could do about that. If they're being if they're guarding their information, I mean, maybe there's reason for that. Maybe they have policies about, the privacy or something like that. Maybe that's why they're not giving it out. But I definitely commend you for trying to take that extra step and do everything you can beyond what you're required to do to try to alert those people. That might be the best answer I have. Do you have a follow-up to that?
No, thank you very much. I appreciate it.
Thank you. All
So
right.
Nate, if there's two names but one address, do you have to send two separate letters, or can you just address it to both names at the single address?
That's a good question. Because usually we hear the opposite. It's like it's one person and two addresses. And in those situations, we always say, yes, send it, cover yourself, send it to both. Like don't risk it. But yeah, two names and one address. I guess it depends. I know there's standardized DOR forms that you use as part of that notification process. I'm not sure if that covers that question. Yeah, I think the biggest part is making sure it goes to the right address. But yeah, that's a good question. I don't know that answer for sure.
And some of them will say like it's like obvious that it's like a husband and wife, or
Right.
and so they're like joint owners or
Right.
something like that. But then there's also, I've had some recently that have been like something about survivorship, or I can't remember I don't have one right in front of me, so I can't tell you exactly what it says, but I think one of them said something about like a beneficiary on survivorship or something along those lines. But it's still the same, like two names and then just one address.
Right. Yeah, that I don't know for sure. I think probably the way we would look at it is that it's going to the right address. That's probably the bigger thing that we would be concerned about. But I mean, it's a good point. Yeah, I don't have a definitive answer for you. If you're concerned about it, maybe that's one where it's worth spending the extra $5 and sending it to both at the same address. Maybe that's worth it just to make sure you're covered. But I don't know, just the way it's sounding, it doesn't sound like that would be a huge issue to send it to both individuals at the same address, kind of as part of the same action. But I don't know that for sure. All right, Zach. Looks like you have your hand raised.
Hello, sir. Zach Russell with Waltz Towing in Colorado Springs. I do have a follow-up question in regards to the no results. So you said at the time that we get the national search back from DOR, and if it comes back with no results, the process is stopped. Now the process stopped, meaning there's nothing more we can do with this vehicle, or we can still move forward with having to title it or get paperwork for it with having no results. And if so, do we have to wait that 30 days still past the no results before we do so?
No, I don't think so. Because again, it's pretty clear in the statutory language that this process is set up to alert the vehicle owners and any lien holders. Like that's what the statute is for. But if how it's practically being applied, which is again running that IDS search first to look at all the state records for that, but say it doesn't have a Colorado plate, it has a Tennessee plate, for example. And again, you're going to run that IDS search as part of the process, and that's the way it's always been. Then if there's no record, it then triggers the national, and DOR has set up their own mechanism for how that part of the process works. But if they come back and say no other records are found, basically you're in a place where there's no, the statute doesn't indicate what the next step is at that point. So that stage of the process is essentially over. And so again, as long as you're keeping all your paperwork and you're able to demonstrate that you participated in the process from beginning to end, which is again the IDS search on the first part, and then the national search on the second part. And as part of taking both of those steps, there's just no record. That means there's no one to send a letter to. And so with no one to send a letter to, there's nothing else that can be done at that point. So at that point, I think I'm pretty sure that the PUC and Department of Revenue are on the same page on this. At that point, that part of the process is over, and you move on to the next stage, which is what, appraisal. Well, it would be. I think it would still be. You may want to check with DOR on that to see if they want you to wait that extra 30 days. Because basically, once you've gotten to that process and there's nothing more, it's not like there's a letter out there and we're waiting to see if somebody reads it and calls us back. So I would probably check with DOR on that and see if they still want you to wait that 30 days from the day they give you the no results from the national. That's a good question. I would probably ask DOR about that.
Right, and I appreciate the information. It's not something we've ran into, very often, but it has happened a few times. And we've waited those 30 days and then been able to title those vehicles. But just wanted to make sure that just because it's worked doesn't mean that's the way we're supposed to do it. So I was trying just clarifying.
Yeah, basically anything beyond the statutory notification process is handled pretty much exclusively by Department of Revenue. So as long as they're comfortable with what you're doing, I assume we will be as well. Because again, it's not, those statutes are not the PUC statutes. They're Title 42. Those are our statutes. So we're going to be pretty much comfortable with however Department of Revenue is managing that process.
Copy. Thank you, sir.
Thank you.
I think Bill did touch on that at the training last week that TRPC put on, that if there is no record found, that we can start that title process immediately. But it might be worth a phone call just to make sure that that is correct. But he did kind of indicate that last week.
Okay. Yeah, and I couldn't remember what Jim may have said about that. So yeah, maybe he touched on that and I didn't hear it, but yeah, again, as long as they're comfortable with how you're handling it, then I don't see what we would say or do to be in conflict with that. All right. Any other questions? We're coming up on 2:30. All right. Well, again, we did share my contact information a little bit earlier. So again, if you want to reach out, feel free to give me a call or you can email me. I answer questions like this all the time. So feel free to give me a call or shoot me an email at any time. And, we'll try to guide you as best we can through the statutes, through the regulations. And I just want to say thank you to everybody. I mean, this is what you're all doing, just being here today for something like this is being proactive in your regulation. And I always will encourage that and commend that, because some people don't. Some people just sign up for a permit and they just are out there working and they never participate in stuff like this. They don't go to the trainings. They don't call and ask questions. And they may be doing stuff incorrectly, and they're not going to hear about it until we find out, and then we're citing them for something. So it's always better to start off on the right foot and just work with us. And I think you'd hear from a lot of people in the industry that we're decent, a decent regulatory body to work with. We try to be as flexible as we can and as understanding as we can. We're not out here to, just find people for every little thing. I mean, that's not what we're about. We're about compliance. We always have been. As long as I've been here for like a decade, and we've always been compliance first. We want you all to do things right and to do it right from the get-go so we don't have problems down the line. And again, just thank you everybody for being here and participating in this. And I hope to see you all again on November 17th and December 8th to cover the other topics. So definitely thank you everybody today, and have a good rest of your day. Thank you.